Sikshayati, platform for eminent authors, engaging teachers, successful students. To know more, email. Assignment of contracts. Assignment of a contract means transfer of rights and liabilities under the contract to a third party. Assignment by parties. Assignment of contractual obligation and contractual rights by the parties themselves. Operation of law. Automatic assignment by operation of law. Assignment of contractual obligations. Assignment of contractual obligation means transfer of obligations under the contract to a third party. Rules of assignment of contractual obligation. Personal skill. Contractual obligations involving personal skill or ability cannot be assigned. Example, a painter cannot assign his obligation to paint to another person. Third party performance. Promisor cannot compel promisee to accept performance by third party. Example, A owes B rupees 1000 and C owes A rupees 1000. A cannot ask B to realize from C unless B agrees to such term. Original party obligations. Parties may agree to allow a competent third party to perform, provided the contract does not contemplate performance only by the promisor. But even then, the original party remains liable for the proper performance of the contract. Example, A undertakes to do some work for B which needs no special skill. B cannot complain if A gets the work done by an equally competent person, but A still remains responsible for performance. Novation. Novation means transfer of liability of one party to a third party with the consent of the other party and of the third party. Novation is a new contract substitution of an existing one between one of the parties and a third party, discharging the old contract with a new one. Assignment of contractual rights. Assignment of contractual rights means transfer of rights under the contract to a third party. Rules of assignment of contractual rights. Personal skill. The rights and benefits under a contract not involving personal skill may be assigned subject to all equities between the original parties. Example, A owes B rupees 5000. B can transfer his right to C to recover the amount from A. If A has already paid rupees 2000 to B, C can recover only rupees 3000 from A. Actionable claim. Actionable claim means act, event, rights, etc. when there are legal grounds for basing a lawsuit on it. Examples of actionable claim. A owes rupees 1000 to B. B's claim is an actionable claim because B can bring an action in a court and claim back the amount. A borrows rupees 1000 from B and mortgages his house to him. Mortgage is not an actionable claim. A contracts to buy goods from B. On the due date, A fails to take delivery and B sells the goods in the open market at a loss of rupees 1000. B has a right to claim the damages from A, but this claim is not an actionable claim. A contracts to sell B 100 bales of cotton deliverable on a future day. B has a beneficial interest in the goods and it is an actionable claim. Assignment of actionable claims. An actionable claim can be assigned only through an instrument in writing giving a notice of such assignment to the debtor. Assignment by operation of law. Assignment by operation of law takes place on happening of some event without any action from the parties. Rules of assignment by operation of law. Death. Upon the death of a party to a contract, his rights and liabilities under the contract, except in the case of contracts requiring personal skill or services, devolve upon his heirs and legal representatives, called successor, through succession. Insolvency. In case of insolvency of a person, his rights and liabilities incurred previous to adjudication pass to the official receiver or assignee. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.